Afternoon, everyone. Welcome to the third in our series of webinars on the Mental Welfare Commission's Good Practice Guides. For the next hour of your time, we hope to talk you through a couple of our guides on, the first one will be on nurses' power to detain, followed by our guidance on care planning. So my name's Claire Lambs. I'm the Executive Director of Nursing here at the Mental Welfare Commission, and I'm joined by one of the nursing officers, Mary Leroy. Our first presenter for the afternoon is Susan Tate, a nursing officer. You've got all nurses today, who will be doing the power to detain, and followed by Anne Buchanan. What we hope to do is to take questions, and as they come up, if you could pop them in the Q&A box. If there are any complex ones, we'll get back to you through our inquiries line, but equally if you've got follow-up questions you want to ask, please use the MWC Inquiries website or email to get in contact with us. The other thing is we will keep your cameras off and your speakers off. It creates a bit of a distraction in terms of getting through things, but once the presentation's done, we'll hopefully get through as many questions as we have, and then we'll move on to Anne's after Susan's. The other part of this is that we hope to have the videos for this. These will go onto our website as soon as we can formalise them and format them. So within the next week, and then after that, we'll send out the series of 7 that we've done over the last 8 or 9 months. So without further ado, I'm going to introduce you to Susan Tate, who will start the Nurses' Power to Detain. Over to you, Susan. Thank you.
Welcome to this webinar on the Nurses' Power to Detain, also known as the Nurses' Holding Power. I'm Susan Tate and have been a nursing officer at Mental Welfare Commission since 2005, which was actually when the Mental Health Act 2003 went live. So there's been a fair bit of time gone past. There will be an opportunity at the end of this presentation for any Q's and A's. So I'm going to take a walk and talk through the MWC advice notes, starting at point 4. I'll give you a few seconds to look at 1 to 3. And for the purposes of this talk, I will presume that the patient does not agree to stay. This flowchart helps nurses decide whether it is appropriate to use this power or not. When this is considered, it should be taken into account that it must be done within the appropriate legislative framework. Failure to do this may be a breach of Article 5 of the European Court of Human Rights, the right to liberty and security. The law states that this can only be activated in hospital, which usually means a mental health or learning disability hospital, but may possibly be used within a general hospital, but that would need to be considered on a case-by-case individual circumstances. There are some examples in the advice note for people to look at. The law states that the nurse must be of the prescribed class, which effectively means that they are currently registered with the Nursing Midwifery Council and are either an RMN or RNLD. If the nurse does not hold this registration and considers the circumstances so serious that the person still needs to be detained in hospital, then common law should be considered, which is to save life or prevent serious deterioration. The nurse must believe that the patient meets the criteria to apply Section 299, that they have a mental disorder and or personality disorder and or learning disability, and that they are a risk to themselves and or others, and that it is necessary to carry out a medical assessment to determine whether an emergency detention certificate or a short-term detention certificate is warranted. This section can only be applied if a doctor is not immediately available, i.e. not on the ward. The nurse must now explain to the patient that they are being prevented from leaving the ward using Section 299 of the Mental Health Act and why. It is sometimes useful to have a brief written statement which can be individualised, as it is likely that the patient will be in a distressed state and not always able to process verbal information. It may be necessary to use physical restraint to prevent the patient from leaving. As always, this should be with the minimum of force and the minimum of time required. The next step is to contact the duty doctor to request an urgent assessment and record the time that this is done. This is really important. The section 299 only lasts for 3 hours. Prior to 2015, it was only 2 hours, but was amended to increase the likelihood of a mental health officer being able to attend. The order falls after 3 hours and cannot be reapplied. However, if the same conditions are still in place that activated the order, common law and duty of care are required to maintain the safety of the patient and others. The doctor then arrives in the ward. The medical assessment is carried out, and if the doctor believes that the patient meets the criteria for detention of either an emergency detention certificate is granted if no mental health officer is available, but preferably a short-term detention certificate with mental health officer consent. Mental health officer should be informed of the detention under 299 if it's an EDC that's granted. The nurse must now complete the form NUR1, giving a clear account of the circumstances in which it was used. It must then be delivered to the hospital managers, and there's a link on the last slide where the form can be found. The hospital manager must now send this to the Mental Welfare Commission within 14 days. So that's the bones of it. And now I'm going to put some meat on the bones. And there's 2 scenarios. These scenarios occurred in an adult acute ward. Details and names have been changed to protect confidentiality. So I will actually read through them as I put them up. So the first scenario is Justin had been in an acute mental health ward for 3 days. He has a mild learning disability and a schizoaffective illness. He lives with his mother and he has a crisis plan which is shared with his mother, as she is with his consent, as she is his main carer. Justin normally keeps well on a depot and monthly meetings with his CPN. Just prior to admission, he had a rapid deterioration of his mental health, which included hardly sleeping or eating, and he was stopping cars outside his house by standing in the road to ask the drivers their names. He was assessed by his CPN and psychiatrist, as it was thought that an inpatient review of his medication and a safe setting for him would be appropriate. He agreed to this. He was still sleeping and eating poorly, and he'd begun to draw trains and cars that held significance to him. And if it was attempted to divert him from this for meals and personal care, as a result, he became very irritable, bordering on aggression. The afternoon of his 3rd day, he decided he had to leave the ward, as he believed that his next-door neighbour was going to rape his mum. He said he knew where the big kitchen knife was and planned to stab his neighbour. The senior charge nurse spoke with him and asked if he would wait to speak with a doctor. He declined due to his belief and concern for his mum. He then pushed the nurse over and tried to leave the ward. As a result, he was prevented from leaving and was told why, and that the nurse needed to keep him in hospital under section 299 until he was seen by a doctor. The doctor and mental health officer arrived on the ward within 40 minutes, and he was detained on a short-term detention certificate. So this is an example of the correct use of the nurse's power to detain. On to the next scenario. Okay. So scenario 2, Canna was admitted to the same ward 2 days ago on an informal basis. She has a diagnosis of EUPD and was experiencing a high level of anxiety, which interfered with her ability to manage her life safely. She made a serious suicide attempt and was admitted to the ward via accident and emergency. Initially, she was content to stay on the ward for a few days, as this was all that she believed would be needed to help her stabilise. At 5 a.m, she decided she wanted to leave the ward as she was experiencing impulsive thoughts of self-harm. She said she couldn't cope with her feelings and wanted to end her life. She planned to throw herself in front of a car. She told the staff to open the door to let her out. The nurse tried hard to persuade Karen to stay, as he was concerned for her safety. She continued to insist, saying, "I know my rights, I am informal, and you can't stop me from leaving." The nurse continued to tell Karen that he could not allow her to leave, and the whole situation lasted about 2 hours. Eventually, Karen agreed to the nurse's request. The doctor reviewed her later that morning and at that point considered that she did not meet the criteria for detention. This is an example of de facto detention, where Karen's right to liberty was breached without any legal authority. Whilst there was good intentions by the nurse to manage the situation, it should have been with a section 299 of the Mental Health Act. So those are the two scenarios. So these are just some thoughts. Why in the ward, same ward, a few hours apart, did these situations occur? Was it to do with the confidence of the nurse, the time of day, patient's diagnosis, access to medical treatment? So these are just some thoughts for any discussion. So I'm going to just go over the Mental Welfare Commission carried out a review in 2023 from January to March, not March. We carried out a review of the NUR1s. We receive an average of 150 to 180 forms per annum, with approximately twice as many women being subject to Section 299 of the Mental Health Act. Interestingly, more men than women proceed to detention under either EDC or STDC. The highest number was in the age group of 25 to 64. And at the time of the review, one rural area had a disproportionate application. It seemed to be because it was in a rural setting. So this is just a glance at the nurse's power to detain, the NUR1s, which there's a link to at the end of the slides. And this is linked to the actual advice note and the NUR1s. So thank you for listening, and please do ask any questions and we'll do our best to answer them. So that is a very quick run through, but it is fairly straightforward. I guess the most important thought is for individuals to be taking into consideration at the point is when do you actually use the power, because often nurses do tend to want to help the patient, just alleviate distress, but when does it go from coercion into de facto detention? So that's the last my presentation. So I'm going to pass over to Claire just to introduce Anne. So thank you for listening.
Susan, and I think it's useful to add for anyone that's on the call, there are two options here. You can always contact the Commission. We have an advice line that's open Monday to Friday, 9 till 12, 1 till 4. And if you have any questions about it in terms of, as Susan was saying, when you complete the NUR1 form, the detail that's on it is useful in terms of looking at trends. We also annually report on the use of 299, given that it sits under the legislation, and we report on that through our Mental Health Act monitoring. So for those that are interested in following over, as Susan's saying, sometimes we see disparities in certain areas, and that might be down to a change in service, it might be a change in need, it can be a variety of things, but it allows you to look at that, and we break down per health board area. So thank you.